Good morning, everyone. I'm Neela. I'm an associate of public policy at JustAct, and a very warm welcome to everybody. I'm delighted to be moderating today's session. First of all, thank you, everybody, for taking time to join us on a Saturday morning, choosing to spend part of your weekend thinking and engaging with us. It is my absolute pleasure to welcome our speaker for today, Advocate Saai Sudharsan. Saai Sudharsan is a familiar name across both student and professional circles, not only for his legal acumen, but also for his willingness to mentor, help out, and engage with young professionals. A few of my peers are among his beneficiaries. He is also predisposed to contribute meaningfully to the legal community. A little bit more about Sai. He is an independent in his independent practice, he represents clients in corporate litigation, arbitration, insolvency resolution, and restructuring matters. He is also a regular contributor to several respected legal blogs, journals, and newspapers, writing extensively on legal and policy issues. If you have not already, I would suggest you look them up, as he has a strong penchant for breaking down complex issues poetically. He is also one of the chief specialist editors for a few leading guides on law on IBC, Prevention of Money Laundering Act, K. Krishnamurthy's Handbook of Criminal Law, etc. He's also working on a publication in honor of retired Justice Rohinton Fali Nariman. One of his recent achievements is that he was inducted as the youngest member into the board of the esteemed Nani Palkhivala Arbitration Center. Many, many congratulations to that. Sir, it is truly an honor to have someone who is active in practice, scholarship, and discourse with us today. Thank you for taking the time to join us and share your insights.
Thank you.
Yeah, it's our pleasure, sir. With that, and without further ado, let's begin our discussion on can collaboration unlock India's ADR ambitions? I was hoping to start this discussion by reflecting on what has changed for arbitration in the last few years. Rather, one of the biggest changes in arbitration in the last few years. So, the Arbitration and Conciliation Act 1996 does not differentiate between institutional and ad hoc arbitration. Section 218 defines arbitration as any arbitration, whether or not administered by a permanent arbitral institution, speaking to the function, not mechanism. So, a very limited recognition to institutions in the statute. Therefore, prior to the 2019 amendment, arbitral institutions largely derived legitimacy from market confidence, quality of their rules, and the caliber of their arbitrators. The 2019 amendment, although never notified, signals a departure from this limited nominal recognition, proposing a framework through which arbitration institutions could be recognized and graded against certain standards. Essentially saying you being an arbitration institute alone is not good enough anymore. So does this shift suggest that institutional arbitration as a mechanism has come to be viewed as performing a role that warrants this distinct legal recognition, reflecting its distinct characteristics in the light of increasingly significant role played by them?
I think the answer to that will most likely depend on how India has viewed institutional arbitration over the past few decades. In India, we advocates and the litigant community as a whole, we generally look at arbitration institutions as nothing more than arbitration centers that facilitate arbitration proceedings. You've had ad hoc arbitrations which ultimately take place in centers. And these centers, even if they are institutions in their own right, they do not have their own set of rules being implemented for many of these arbitrations. So this is basically down to culture. And to answer your question, there has been a consistent effort taken on part of the advocates, the arbitration bar especially, as well as Parliament, to introduce institutions as a concept and to push it and give it an enormous amount of implementability, if I can put it that way, However, as you correctly pointed, we faced a lot of roadblocks. Primary roadblock being that even though the 2019 amendment has come in, the arbitration council as such has not been introduced. There is no constitution of the council, even though the enactment introduced several new provisions. And you've had back and forth when it comes to how this council should function. But to take it from the first step itself, again, it's all down to, I would say, the culture. As I mentioned, we've always had this idea that arbitration institutions basically facilitate arbitration, but they are not just that. They are, I would say it's a very legally convenient and at the same time an institutionally false statement to make, that institutions are nothing more than centers that facilitate arbitration proceedings. In fact, arbitration institution, if you look outside India, and few of the premier arbitration centers in India, including Nani Palkhivala Arbitration Center or your MCIA, all these are not just centers where you have proceedings conducted, but they have enormous powers that arise as a consequence of the rules of these centers, rules of these institutions being introduced into the arbitration agreement itself. They have the power to appoint, confirm, and even sometimes remove arbitrators. They resolve challenges to appointments. They fix and collect fees of the arbitrators. They can have the power to join parties, consolidate proceedings. Primarily, the reason behind going for arbitration institutions, especially outside of India when it comes to international commercial arbitrations, is that they monitor time and they monitor the progress of the arbitration proceedings. And these rules are what basically pushes litigants to go for arbitration institutions. Because even outside of India, even though commercial litigation is much faster, they are seen as being not as fast as arbitration proceedings. In India, however, as I mentioned, we have this tendency of introducing the same CPC practice into even arbitration proceedings. And the attitude of advocates as well as litigants is that ad hoc proceedings is a little more flexible. To the contrary, I would say it is not, primarily because even if it is flexible in granting you more time in the form of adjournments, or for that matter, having a trial conducted in a manner very similar to a civil proceeding, ultimately you end up losing on something which is very important. That is time as well as consistency. And coming back, for arbitration institutions to take root, it has taken root, but not grown maybe. To grow in India, I would say the primary thing that all these institutions should focus on is consistency and creating a value ecosystem. That is where I would say collaboration, that is where I would say the need for moving forward when it comes to even rules that we already have. Because some of the rules that these institutions have had, they've had it for years. And as you can imagine, times are changing. You've had, since 2020, many arbitrations moving completely online. And you've also had international commercial arbitrations where you don't right now have the need to travel outside India. If the parties agree, if the arbitrators agree, you can ensure that everything is done from where you're sitting. But at the same time, you also ensure consistency. You also ensure that parties are given the right. Parties are able to defend their cases, prosecute their cases properly without any influence. So I would say there is a shift, not just in India. Internationally, there is a shift. But for India to be on the same level, same playing ground as other international institutions, I would say we need to ensure that, firstly, the 2024 amendment, which was also in the form of a bill still, but anyway, that was proposed, all that has to be implemented to its fullest. And you need to have courts pushing for institutions to take up even appointment. That's where I think the first push should come from the courts, in not appointing arbitrators, but only coming in where there is a need when it comes to arbitration.
Yeah. So thank you. So for being patient with the prolonged subtext and question, your response, I believe, will help us reflect and deconstruct this transition that has been happening over the past few years with more clarity. When you said that arbitral institutions are not just centers of arbitration, you basically manage the process and experience and the enforcement and the impact of arbitration as a process in its entirety. So, on a similar lines, I want to ask a question on the dynamics between legislating about these arbitral institutions and the principles that arbitral institutions are supposed to uphold. So, if the law were to prescribe minimum standards like they have done in the amendments for institutional arbitration, to what extent can they do so without coming in conflict with the fundamental principles of arbitration, like party autonomy, where you're not restricting the promise of flexibility and expediency that arbitration promises? So where should the law draw the line between ensuring fairness and avoiding encroaching upon party autonomy that lies at the very heart of arbitration?
So to answer that, let's first look at what is important for arbitration institutions to uphold, especially when it comes to highly contested matters such as, let's say, a construction arbitration, or for that matter, a very paltry sum in respect of a liability to pay. So here, these principles are applicable even to ad hoc arbitrations, I would say. Firstly, as you correctly pointed, the fundamental basis on which everything revolves when it comes to arbitration is party autonomy. Second, I would say there has to be independence and impartiality of disclosures that you have in the form of Section 12 already in place. You have the 5th and 7th schedule, which were brought in recently. Another important component would be equal opportunity of hearing and fair hearing being offered to all parties who are involved. And you have the same requirements of civil proceeding, for instance, reasonable notice, procedural participation. You also need transparency in appointment of arbitrators, transparency in the way they are removed. You need to have recent awards, and these recent awards should be subject to the timeline prescribed under the Arbitration Conciliation Act. You need to have arbitral institutions ensuring that the conflict check mechanism that they have in place is robust. You need to ensure that basic timelines under the Arbitration Conciliation Act are met. But at the same time, the arbitral institution should itself be a little more proactive in ensuring that these timelines are met. It is not enough if you leave it to the arbitrator or the tribunal, because these basic timelines and procedural conferences, if they are done properly, what is left is only to hear the parties. What is left is only for the pleadings to be completed and for the award to be delivered at a later stage. All this, if you get the procedure correct, if you get the opportunity of hearing properly in place, and finally, what would be is the cost component, because cost component and safeguards against any sort of unilateral dominion over the procedure. Final components are in place. Any arbitral institution will be able to manage the proceedings properly. But to answer I would say, in a different way, your question also poses another related question. So if there were to be amendments to the Arbitration Conciliation Act to boost arbitral institution, but at the same time keep a check on them, what should that be? So we've had different ways of dealing with it. The Parliament itself seems to have deviated from the initial approach that it adopted in 2019. 2019 basically introduced a series of amendments in a series of sections into the Arbitration Conciliation Act to ensure that arbitration conciliation was taken seriously, to put it mildly. You had the Arbitration Council being brought in. You had sections 43A to 43M being introduced. You had amendments to the definition of arbitration institution. All this was brought in. But one of the key aspects of this amendment was that the Arbitration Council was not only tasked to recognize, because the recognition itself, as per the 2019 amendment, came from either the High Court or the Supreme Court. So, under the mechanism envisaged by the 2019 amendment, you had arbitration institution being recognized by the High Court or the Supreme Court. And post that, there was an accreditation aspect which was to be done by the council. The council here was basically empowered to grade institutions based on the metrics that they were to come up with. And that was always going to be an issue, as you can imagine, in India, because that's a system which is bound to be played around with. So one of the, I would say, good aspects of the non-implementation was that the accreditation is right now being done away with. You've had the Dr. T.K. Viswanathan committee report coming in 24, where he also stresses on the same point, where he says that the Arbitration Council basically should not be an accreditation body, but rather it should ensure that there is a facilitation in ensuring that there is fairness from arbitration institutions. This is the same formula adopted by England also, where you do not have accreditation, but they only set up mechanisms to ensure that the points that I mentioned earlier, a fair opportunity of hearing, cost, as well as the other points that I just mentioned, are all taken care of. So there is a need for these institutions to ensure that their levels, their commitments to these various rules are met. But at the same time, it's for the market to choose at the end of the day. It cannot be that basis the accreditation, certain institutions are favored over others, because ultimately it all comes to two aspects: procedure and ensuring that the procedures are followed. These are the two main things that an institution should do. So accreditation would have basically tilted the market itself towards moneyed institutions with powerful backers. Instead, the 2024 amendment bill, it basically takes from the Viswanathan committee report, and they also do away with the accreditation process. So, that way, I do think we should adopt the English formula.
Okay. Thank you, so for reminding us, when in doubt, always go back to the basics. So what I understood is, so law in this context has to set a minimum protections for the parties, and arbitral institutions focus more on setting procedures and adhering to the procedures. So basically self-regulating how they operate. And it's left up to the market to choose what kind of procedures they would want to adopt. So I want to focus a bit more on the procedures of institutional arbitrations. I have been asking pretty much normative questions so far, so I want to come down to what is happening right now around us. So our institutional arbitration is not a sudden new concept, right? It has been there for quite some time, but it has now been increasingly seen as the future. So I want to talk about, when we talk about institutions, talking about architecture of the institutions becomes necessary. So when we look at premier institutions like SEAC, LCIA, ICIC, and NPAC, it is the institutional architecture that sets them apart with their own built-in procedures and guardrails to ensure a due process is followed. So, briefly, can you, with examples of what kind of procedures or what kind of good practices, institutions need to adapt so that quality, finality, and enforceability of arbitral awards uh, or increases. So how do these play a role in reducing preventable judicial intervention at the post-award stage, like you were talking about in the previous discussion?
Sure. So when it comes to, fundamentally one mistake that we keep making India when it comes to arbitration is that we seek to transplant procedures, provisions as they are from outside of India. And I would say this is even applicable to arbitration institutions. Primarily because we have the model law, which was more so applicable in case of international commercial arbitrations being implemented even to domestic arbitrations in India. So one of the things when I was speaking with one of the framers of the Conciliation Act, Arbitration Conciliation Act, what he basically told me was we should not be transplanting it as it is. We were forced to do it at that point in time. We had multiple compulsions. We did it. But ultimately, we do not have the culture to back it up. So we see this playing out in other similar legislations as well. I would say the same issue is there when it comes to insolvency and bankruptcy court, where you have the entire legislation being copy pasted with minor modifications, but that ultimately does not suit us. So when it comes to Arbitration Conciliation Act, you have that playing out when it comes to our domestic arbitrations. You do not have this, even though the law provides for the safeguards, even though the law ensures that there are procedural fairness as well as substantive fairness being met, you still have the issue of unfamiliarity. Because one of the things that the Arbitration Council was supposed to do, which I think whenever it is introduced, it should do, is to ensure that the arbitration bar is built up properly. And to ensure that the very fact of time efficiency and also procedural efficiency are inculcated into the litigant as well as the advocate communities. So that's very important. Without basic education, I would say, even if arbitration institutions do great things with their rules, adopt from outside, improvise within our own means, ultimately it comes down to this basic fact that we need to be educated about the basics of arbitration. We know the basic of what an arbitration proceeding is, but the purpose of it should be instilled a little more is what I'm trying to say. But coming back, your question of what is making these institutions, let's say LCIA or the SEAC, England, for instance, it basically adopts a very free market system where, as I mentioned earlier, all you need is under the 2025 Act, even under the 96 Arbitration Act in UK, was that you needed institutions to be impartial tribunal, to be able to set up impartial tribunals and provide parties with the freedom, but at the same time make them subject to public interest. So the LCIA remains a private institution. LCIA, even though it's the premier institution based out of UK, it has its own setup where the bodies running it have more freedom when it comes to the rules. As long as you meet the minimum threshold being fairness and the other things that we discussed, they've given a free hand with respect to procedure. So that's something that India should look to, where the institutions not just play fair, but they also have a system in place where they build it over years. It's not going to happen with the introduction of new rules alone. It has to be implemented consistently over years to earn that respect. That's from the institutional point of view. But ultimately, we are, facing a judiciary which is very influential and very ready to intervene. And even though you've had amendments over the years coming in, 2015, 19, all setting up, corners so that the courts do not go beyond those brackets. We still have interference. We still have the same questions being played out on basic procedural aspects. You've seen it happen time and again. So interference should reduce, and ultimately it should empower these institutions to play around with their procedures, but at the same time, the minimum threshold is met. Let's take SIAC, for instance. SIAC mostly deals with International Arbitration Act of Singapore, and the procedure there is that the 2025 rules of SIAC, for instance, it permits the Secretariat to refuse nominees and depart from agreed appointment methods if it feels that there is unequal treatment happening when it comes to the appointment process itself. So you have institutions empowered to that extent in Singapore. Even though Singapore arbitration community, I would say, especially the system that they've adopted with SIAC, is unlike England, a little more public-private hybrid system, where the International Arbitration Act itself basically recognizes the president of SIAC as being the default appointing authority. So all this is there. So we cannot ultimately import all of this to India because it does not suit us. We have to basically empower these institutions to play around with the rules firstly, still meet the minimum threshold, and finally, there has to be very little interference when it comes to the awards, when it comes to appointment. I would say where it should start is from appointment itself.
Yes. Thank you, so for beautifully dissecting the dynamics between institutional architecture and how institutional architecture should be underwired by being faithful to the principles on which arbitration was built and giving it time so that a culture of arbitration is built by each of those institutions and giving them room to build that culture and giving them flexibility to do so, and how it will eventually lead to positive consequences, pertaining to enforceability and finality and all those things. So if we keep talking about institutional arbitration, I think we can keep going on and on. But I want to come back to the theme of this session, which is collaboration. And speaking of collaboration, I want to focus a bit more on the NPAC and JustAct partnership. So the partnership between JustAct and NPAC brings together a tech-driven capability of JustAct and institutional credibility and arbitration culture that's ingenious to NPAC to build a modern dispute resolution mechanism. So put simply, for our viewers, what does this collaboration mean? Or rather, what should it mean for how we are going to adjudicate disputes going forward?
When it comes to the two institutions that we're talking about, you have Nani Palkhivala Arbitration Center, which remains one of the very few institutions recognized as an arbitration institution in India. It was recognized by the Madras High Court in early 2000s. And you have this legacy that it has built over the years. Legacy of commitment to impartiality, a legacy of commitment to procedural propriety. And you have doyens of the bar running it, and they've been leading it from the beginning to today, where they've taken it to, I would say, the premier institution in Chennai, if not in India. And JustAct, as you correctly said, is a tech-driven startup which has built its own legacy. It's, I would say, one of the, when it comes to transcription as well as arbitration services, it's one of the top in India, and it has obviously been doing arbitration for other institutions as well. And when we see the people manning JustAct, you have enthusiastic and dedicated people who have a vision. And NPAC, obviously, with this collaboration, I would say, is taking it to the next frontier. We have the legacy of Nani Palkhivala Arbitration Center, and you have the capabilities, as well as the vision that the founders of JustAct bring in. And I think the two collaborating together is a good thing for the arbitration community as a whole, not just for the institutions themselves. It's ultimately not just about self-promotion, if I can put it that way, but it's about bringing in the capabilities of both these institutions together. And I do believe, especially with ODR and video conferencing being the norm, we will be able to also ensure that the procedures which we will together implement, at the same time the ways and means of doing the arbitration proceeding itself uh, is bettered. And I'm looking forward to this collaboration. Having known the founders of JustAct and being part of NPAC myself, even though I'm quite new, uh, I am very hopeful and I am looking forward to this collaboration.
Yeah, thank you. Thank you for responding to that. So it's two institutions, both pioneers in their own respective journeys, so have come together for a shared vision. So greater realization of this vision awaits us all, surely. So I want to dig a little bit deeper into this. So because the vision is incredibly expansive, right? Like stretching from bringing efficient resolution to low value, high volume disputes in tier 2 cities, all the way to handling complex cross border commercial disputes. So, for a partnership, for a mechanism to be able to handle all this, it needs to be both malleable and resilient, right? To uh, handle the wide spectrum of disputes. So, how do you see this particular partnership responding to this demand of malleable yet resilient uh, requirement?
Very interesting question. Because as I mentioned, when you have legacy of NPAC, you always look at it from the point of history. And when it comes to technology startups like JustAct, you look at it from the perspective of future, from the new technology that they bring in, but at the same time the new ideas that they bring in. I have used JustAct products, for instance, and one of the things that I really enjoy about them is, for instance, the secure document handling, the communication capabilities, as well as the digital case management. And you have the institutional trust that NPAC brings in. You have a vetted panel of arbitrators, you have scrutinized procedural groups, and you have, more importantly, the procedural and administrative discipline that's been built over years. And when these two are put together, especially the ODR skills and architecture that JustAct brings in, I would say it not only will result in awards that survive judicial scrutiny to be subtle, it also translates to frictionless justice delivery. And that, I think, is the future of arbitration. And ultimately, we are looking at a world where tech is going to take over, is something that we advocate here day in, day out. And this is, in a way, future proofing NPAC as well as the arbitration community, because there is, I would say, this is one of a kind collaboration where you have these two institutions fighting for the same fight, which is frictionless and quick justice delivery. And that I think is achievable with the capabilities of both these organizations.
Yes, thank you, sir. That's the future we all, look forward to. So now this particular partnership is, within the ecosystem of ADR and ODR, right? So we are interacting with each other. So I want to now shift the conversation to how collaborations like this beyond the ecosystem, can help us going forward. So India's ADR ecosystem has witnessed remarkable progress, but um, alongside inevitable setbacks. So for this institutional arbitration culture and institutional mediation to mature into a truly resilient ecosystem, collaboration beyond ADR and ODR institutions is as essential as collaboration within the ecosystem. So as India aspires to become a global arbitration hub, how can we collaborate? Or what kind of collaborations do you think we should be, initiating beyond the ODR community? For instance, with industries, with trade associations, with judiciary, academia, researchers, and international research and arbitration community that aids in this ambition, uh, aids in this translating of this ambition into reality, building lasting confidence of parties, both national and international, foreign investors, so that they build this confidence and choose India as the seat of arbitration.
I think the answer lies in tier 2 and tier 3 cities of India. Because ultimately you have arbitration as a concept which has been going, if not smoothly, at least to a large extent in tier 1 cities. But for arbitration to take root in other parts in India, you need more education. Ultimately, it comes down to that, not just of the litigants, not just of advocates, but also of the judiciary. So when it comes to tier 2 cities, you do not have arbitrations going on in most of these tier 2 cities, primarily because you do not have the infrastructure, which is where institutions such as NPAC comes in, which is why institutional arbitration, once it takes root in these tier 1 cities, it should move beyond them, because the culture has to seep in. And we ultimately, at least when it comes to commercial litigation, we are, I would say, republican in nature. It is the top to bottom approach that we've always taken in India. So it's inevitable as well, because you have major transactions happening in tier 1 cities. So for this to become something more normal, it has to take root in tier 2 and tier 3 cities. And only then there will be actual culture of arbitration in India. That's one part of the answer. With respect to India becoming an international arbitration hub, I would say it should start from the government, because we need to be aware of the fact that government is the largest litigant in India. It has always been, and it will continue to be when it comes to arbitrations, especially. So unless government departments take cue from the government's initiatives and push for arbitrations more, I do not think there is a possibility of India becoming an international arbitration hub, to be very honest. But you have the government itself, the departments themselves, going back and forth. Everyone remembers what happened in 24 when a department of the government basically discouraged the department from going and other departments of the government from adopting arbitration, but rather pushed for settlement mechanisms. When you have that happening, I would say it becomes difficult, because on the one hand, you want India to be an international arbitration hub, and for Indian companies doing business outside of India to have Indian cities as the seat of arbitration. But at the same time, you are discouraging the biggest litigant, which is yourself, from participating in arbitration proceedings. So that's where I would say the dissonance arises. So you'll have to speak with one voice. And unless that happens, it becomes difficult. And the last part of the answer, I would say, is something that we've been discussing from the beginning of the session, which is to build institutions, which is to build systems, which is to build basically institutional guardrails that would push for institutional arbitration to be adopted more. First, there needs to be adoption of arbitration more. Only then you will have institutional arbitration also being adopted more. For tier 1, we are already en route. But with respect to tier 2, tier 3, I think we have a lot of work to do.
Okay. Thank you for clarifying that for us. So what I understand is players outside the ADR, ODR ecosystem, their actions and reactions have an effect on how efficiently we are able to function. Right. So in our March webinar with Hemant Gupta sir, he was also emphasizing on this aspect that everyone inside the ecosystem should collaborate with each other, work with each other, so that we move forward together. So it's always a pleasure to see, discussions about collaboration within the ecosystem increasingly being seen as the way forward. So on this line, so in order to push the government or for the government to give us an empowering environment for us to grow ourselves, there are surely initiatives from their side. So there are expert committee reports, there are amendments, and even courts are pushing for institutional arbitration. So given this conjecture, what do you think players within the ecosystem, what collective steps we can do to reverse this trend so that we can demand collectively an empowering ecosystem or an environment so that we can grow our practices to realize the government's ambitions?
I don't want to make the answer so simple, but I think the place where we need to start Indian would be to speak with a single voice. One thing that we've always faced, at least from outside, anyone you speak to, any arbitrator or litigant, even for that matter, is that the rules keep changing, the goalposts keep shifting. And this has, a lot to do with the way our procedures work. Our policymakers have always had this issue of being reactionary rather than being proactive. And I would say for any sort of commercial litigation to be adopted in a very grand manner, which is what we are aiming, because ultimately we want efficiency and we want results. And results follow consistency. And it is very important at the end of the day to ensure that our business fraternity or litigant fraternity, as well as the international markets, they should get to know that India is a safe destination to invest and a safe destination where you will be able to prosecute your case. Because any litigant in India, or for that matter outside, both within the judicial system or when it comes to arbitration proceedings, the issue that is often repeated is that they do not know when the matter will get over. They do not know the cost. They do not know how many hearings it will take. They do not know what papers they expect to file. They do not know what other litigation the other side might come up with. So these are issues that have been there for decades. They've not changed. The issue is we always try to play the system, and the system reacts rather than coming up with guardrails to prevent the misuse of the system itself. So one thing that has to be pushed forward, I think one recent coming back to IBC is that, for instance, changed the culture of promoter-driven companies in India. Primarily because there was no other way out. Once you get into IBC, they
So I think there is an issue with your
lost control of the company, and there were guardrails. But here you have, instances, provisions of the influence of the court, even 10, 15 years after the award comes in. An award is a decree at the end of the day, but enforcing it is still difficult in India.
Yeah, thank you. Thank you, sir, for these for ironing out the very twisted issues hidden beneath the system. So thank you for picking our brains and helping us think with you. It's truly an exciting undertaking, I must confess. So slightly digressing. So I want to ask a practical or personal question, if I may. So as a successful advocate, especially now we're talking about collaboration and lawyers, and you yourself passionate promoter of ADR, as you can see, and a legal professional closely associated with NPAC. You sit at a unique intersection. We have been talking about judiciary, the government, the institutions. I want to now talk a bit more about lawyers. So while mediation is taking root and lawyers are increasingly embracing arbitration, a common misconception persists that lawyer community inherently a little resistant to ADR adoption because it bypasses its traditional court systems. But people inside ODR and ADR, we can see it is not. But still, the misconception is something that is very hard to let go of, for people outside this ecosystem. So, can you burst this bubble for us, a little bit based on your experience?
Thank you for bringing it up, because it's, I would say, I, as an advocate, frequently encounter this stubborn myth. The idea that lawyers are inherently averse to and dislike alternate dispute resolution mechanisms. The conception is primarily because there is a belief that advocates do not want to bypass traditional courts, because ultimately there is a belief that it doesn't suit or favor the advocate himself. But let me burst the bubble to borrow from you. It's just that advocates are not shying away from arbitration. It's just that we have a tendency to leverage it. Ultimately, we look at procedures and we look at bottlenecks, and we see a way and means to leverage it. So the traditional litigation model, for instance, where cases languish in courts for decades at a stretch, it actually traps an advocate's time. It's ultimately results even speak for an advocate. It is not that advocates want to prolong litigation. Sometimes it is adopted as a matter of strategy, I do not deny. But ultimately, that's not the case at every instance, and that is not broadly adopted as well. The issue is when you encounter delays, it's basically a negative outcome for the commercials of the client. And it is also negatively affecting the advocate's time, because time is the most important thing that an advocate has. It is his currency. ADR mechanism basically is supposed to change that. It's supposed to ensure that the velocity of a law practice improves and increases. And I believe, and I know for a fact, a lot of my brothers in the fraternity also believe that resolving a dispute within the prescribed timeline, you basically obviously can handle high volumes of cases. You have new technology also helping you with doing the menial clerical work getting done. So we are able to maximize our outputs through ADR and mediation. And I come from a school of thought. My seniors and people who I look up to in the profession have always told me, when it comes to litigation, when it comes to arbitration for that matter, if there is a possibility of a mediated settlement, that would always be the best result available to a client. Here you need to understand the fact that clients, the litigants, have been trained to believe that if there is a case pending in court, you do not have to pay the money back. You do not have to take any action. You do not have to resolve the matter, because ultimately they believe the end result is basically the chance is 50-50, because our litigation ecosystem sadly does not guarantee, I would say, results. Even if you have good merits, you cannot always guarantee the results. That's the system we play with. That's the system we are a part of. And that plays in the minds of litigants as well as advocates. So many of the strategies that an advocate is forced to adopt, if I can put it that way, is most often in the interest of the client, because the system demands a certain strategy to be adopted. And not to always blame the system, the Arbitration Conciliation Act was modeled after the model law itself and taken from other jurisdictions to move the fraternity away from this thought process. But however, we have faced bottlenecks. The Mediation Act, for instance, which was introduced in 23, is also drafted with the same mindset. We advocates as well as the policymakers want to ensure that the number of people going to court and settling matters increase rather than number of people waiting in court for a result. But there is no simple solution to it. The system, the players, as well as those who get played around with, fingers have to be pointed to all of them, and not just to one particular constituent of the system. But the way forward, I would say, because ultimately we are discussing about the way forward also, is to ensure that, once the market is free flowing, once people get to know that there is an easier solution, there is a faster solution, there is a way for getting results with certainty, I do believe that the market will mature. I do believe that, because we've seen it happen, outside of India. India is a different playground altogether, but ultimately it is education, it is consistency, and it is belief in the simplest things, and going after those simplest things that will ensure that the litigant benefits, that the advocate benefits, and the whole system benefits. And we'll have to ultimately understand the fact that we do not have, people are getting to know about it, and I think there will be more education around it as well, which is that the courts do not have the necessary backbone to handle all matters, primarily because they have very limited number of judges, they have very limited number of courts, and the system can handle only so much quantity. So once that becomes understandable, and once that is brought to the litigants, they will understand the need for a mediated settlement. They will understand the need for arbitration to be taken up more broadly.
Thank you. Thank you for giving a little bit of insider perspective and burst in the bubble for us, and much more than that, you have also laid out, how we can, move forward from there. Thank you for your response. Mm, I think it's time we have reached end of our discussions. And it has been an absolute pleasure listening to you and thinking with you. And it was indeed truly an insightful session. Have given us a lot more to think about. And so I sincerely hope today's session and discussion has given our viewers not just answers, but also more to ponder about, more to have a dialogue with their peers, have conversations, build discourses. So after all, that is how we move forward, by thinking together, working together, and building systems together. And one important takeaway, I would say, is that we have to start looking inwards and improving our own mechanisms and rule books, and stick to them consistently so that it becomes a culture for each institution, and responsibly adopt global best practices, see whether are they relevant to the area that you're applying to, and being a little bit more responsible about adopting best practices, and also looking upwards to regulators and courts so that we are not trailing off the basic principles that we are supposed to stick to. And this is how we move in the right direction. And thank you once again for sharing your time, experience, and insights with us. It has been such a privilege to host you, and we're truly grateful for your generosity with which you shared your insights. And my sincere thanks also to the JustAct and Multicall teams for making today's session seamless. Behind the screens, a lot more people are working for the success of these endeavors. And finally, to all our participants and viewers, thank you for your continued support. If you enjoyed today's session, please do spread the word. The recording will be available on YouTube, so do revisit it and share it with others who may find it valuable. If your questions were not taken up in today's session, it is only due to paucity of time. We have taken a note of them, and we will try to address them in the upcoming sessions. And as always, if you have any thoughts, questions, or ideas, we would love to hear from you. And once again, thank you so much, Sai sir, for your time. Looking forward to more such conversations. Until next time, thank you and have a wonderful weekend.